IVM.
We are here to remind you to pay your credit card bills because paying on time is a good policy. Credit Power Play gives you a chance to win 100% cashback during the first 6 overs of both innings of any IPL match. Just pay your credit card bill and stand to win 100% cashback. Welcome to All Things Policy, a daily podcast by the Takshashila Institution. We are a bunch of policy nerds based in Bengaluru, and we like bringing fresh perspectives to Indian affairs and Indian perspectives to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to another episode of All Things Policy. Today I am your host, that's Pranay Kotasthane, and I'm returning to All Things Policy after a long time. So good to be back here. And today I have with me Mihir Mahajan, who is our intellectual property rights and law expert. So Mihir is joining us and we're going to discuss a very interesting ordinance which has happened recently. So welcome Mihir to All Things Policy.
Thanks, Pranay. Great fun.
Yeah. So before we get started with this, I just wanted to mention that both Mihir and I teach at the Graduate Certificate in Public Policy courses at Takshashila, and the applications for the next cohort are open. I also happen to be one of the students of this course way back in 2013, and it helped me transition to a career in public policy. So all of you, if you're interested in public policy, want to know more about how India's governance works, do check our courses out. The link will be given in the description. Now, returning to today's topic. If you are reading the news, you would have read about how the center has amended 10 laws to remove some appellate bodies, and that has been done through an ordinance. The name of this ordinance is the Tribunal Reforms Ordinance 2021. Okay, and that was notified recently this month on April 4. So what this does is that certain laws, around 10 laws, which basically abolish around 5 tribunals, ranging from the censor board related film certification to intellectual property, a wide range, disconnected range of tribunals which existed before. This ordinance says that these tribunals will no longer exist. Now, incidentally, this reforms bill was introduced in the budget session in Lok Sabha in February 13. And the argument that the finance minister made was that these appellate tribunals were actually not streamlined, and they were actually slowing down the judicial process. And hence, the idea was that they should be rationalized, they should be moved out, and all these functions which these appellate bodies were doing separately are now to be moved back to the high courts or the commercial courts or whatever. So that is the background. And I thought it will be great to talk to Mihir about one specific ordinance angle in this, which is about the Intellectual Property Appellate Board, IPAB, which deals with patent and copyright, etc. And we'll discuss with Mihir on that. And what is the impact of abolishing such a tribunal on our intellectual property system is something that I was interested in, and Mihir had many answers to that. So Mihir, let's begin. First and foremost, what is the IPAB? Why does it matter? Why should ATP listeners care about it?
Right. Great question. So I think very quickly, the intellectual property laws in India are administered through the Indian Patent Office. And the Patent Office is responsible for registration of patents and trademarks and copyrights, as well as plant varieties and geographic indications. These are all various kinds of intellectual properties that are recognized in India. In many of these cases, for example, patents or trademarks, an applicant who wants a patent or a trademark goes to the office and files an application. And for example, for a patent says, this is the invention I have, here's the forms and paperwork for it, now grant me a patent. What the Patent Office does is it has a trained pool of examiners, essentially scientists or engineers with experience in industry, as well as understanding of the patent law. They have qualified through an examination. They perform an examination to determine whether the application for a patent meets all the standards for patentability according to Indian law. So is the invention actually new? Is the invention non-obvious? Is there an inventive step? And does it actually meet the criteria of industrial utility in the Indian context? And with all of this, there are also procedural aspects of the law. So has the applicant filled out the paperwork properly? Have they paid all the fees and so on and so forth? So there's a administrative component to it, and there's a technical evaluation or legal evaluation component to it. The patent office essentially does a back and forth with the applicant and says at the end of it, might say here you're granted a patent, or no, your patent has been refused, or your trademark has been granted or refused. And at that point, the applicant may be really happy that they got the patent, and that's the end of their interaction with the patent office, and they continue paying maintenance fees. Or they may be unhappy with the decision that the patent office has made, the examiner or the controller, as they are known in India, has made. If a patent applicant or a trademark applicant, or in the case of copyright and other kinds of IP rights, the corresponding individuals or entities are unhappy, then they have to appeal that decision. Now, the first round of appeal goes through the patent office itself. There is a procedure that you can appeal to the controller to reconsider your decisions and so on. But if you don't make headway, then essentially IPAB has appellate jurisdiction against the decision of the controller that you receive. So you may appeal things like, for example, if the controller says that your patent does not comply with the act because of lack of novelty, you may appeal and say the controller is interpreting the law and the technology wrong. Or the rejection might be on any administrative ground like lack of timely payment of fees, or addition of new subject matter that is not permissible, or all kinds of really decisions that you go to the IPAB. Now, traditionally, the IPAB actually did not exist. The IPAB was brought into effect from September 2003, initially for trademarks and geographic indications, and patents and copyrights and others were added at a later time. So in effect, it has only been around for a little over a decade. And there have been all kinds of goods and bads with it. But it is essentially the first place that the applicant would go to appeal. That's why it's an appellate board.
Yeah, that's great. So, yeah, it was where the applicants could appeal against a decision which they think didn't go their way, right? So it's a very important function. And Mihir, often we say, and you've also mentioned about how intellectual property rights management system in India is rather weak or not the strongest that it should be. So in that perspective, what role did the IPAB play?
Right. So to be frank, Pranay, I'm not greatly familiar with all the IPAB decisions and the functioning and so on. But I mean, for example, recent data shows that the IPAB has issued a fair number of decisions, even though it has been understaffed. I have seen information, for example, that the IPAB disposed of 3,700 cases since its inception. So that's from 2003. But more recently, in 2018, it disposed of 663 cases. And in the year 2020, it disposed of 275 cases. Now, granted, some of these cases may be relatively trivial and easy to dispose. For example, like error in naming the inventor, or like some administrative function that the controller didn't read the rule properly and had to be appealed and things like that. But some of it may be substantive as well. So it's not an insubstantial role that it has played. More importantly, also, it is similar to the role a lot of appellate bodies in intellectual property law offices across the world in various governments play. So in some sense, India is not unique in having an appellate board for intellectual property outside of the usual court system. It is the appellate board is a logical first step in many cases of special areas of law and where the government also performs the administrative function. So in that sense, even though it has been understaffed and, for example, has not had a chairperson for over 1,000 days and has had significant delays of more than a year in appointing personnel, it did play some role. I'm sure patent applicants and copyright people in India would probably have good and bad things to say about it. But obviously a body will need, given that it's only been in existence over a decade, and these kinds of systems take time to stabilize and need the resources in terms of personnel and money and so on. Even if it failed to play a role, I'm not sure it can be ascribed to the kind of the legal definition of the appellate body, more so than the administrative hassles, the money and personnel issues that it might have had.
Right. Okay. So now let's do the Indian system of philosophy's Purva Paksha style of argumentation. Right. So Purva Paksha states that you need to present the view of the opposing side in the clearest manner possible before finding flaws in it. Right. So let's try to see what are the best case argument for this move, because clearly the government thought this was very important. In fact, they brought in as an ordinance, right? So the statement of purpose in the bill itself says that the president is satisfied that circumstances exist which render it necessary for him to take immediate action, and hence this ordinance, right? So clearly the government is saying that it was very, very urgent, and hence we have to get it through without parliamentary approval as well. So what are the best case arguments that we can?
Sure. That's actually a nice way of putting it, because some of them actually make a lot of sense. It's very reasonable for a lot of governments to do this at different points. So one is that if you think about the procedural context here, is that the patent applicant is unhappy and is appealing to the appellate board, and therefore there is an adversarial situation here where the applicant is going up against the patent office and saying the patent office got it wrong, and the appellate board is supposed to rule. In that adversarial situation, if pretty much every appellate board decision, let's imagine a situation where the IP appellate board simply just sides with the government, sides with the controller every time, right? Now the applicant has spent all this money in litigation and in appealing to the appellate board and said, here's a decision I want to question. Please rule on the law and please rule on the facts of my case. The appellate board simply, let's say, rubber stamps or otherwise agrees with the controller. That's one step of litigation that is wasted, because the applicant is pretty much going to go to the next logical place, which would be a high court, and say that the appellate board gave a decision that isn't right. Give me remedy now. So the government actually points to this. There is some argument I have seen where it says that any existence of an appellate board can lead to excessive litigation, because it's just one more step between you and the next logical court. But that argument works only if the appellate board decisions were of poor quality and high courts are overruling them. I haven't seen any data of that kind.
Yeah.
The second one, actually, I would feel more comfortable and I think makes sense, which is that these appellate boards have technical members and who are patent agents of significant experience, more than 10 years, and also have experience acting as controllers, as patent examiners. So they are familiar with the government administration as well, which means that the appellate board is at least in theory constituted to have the right kind of expertise to do the job that it is supposed to do. But what it also means is that if there is a requirement in law that the technical member of the appellate board is somebody who spent 5 years as a patent controller, then they are very likely to side with their former colleagues, if you will, in the controllers, or more likely to interpret the law the way the patent office interprets it, rather than necessarily see the other side. So it's subject to kind of a groupthink, if you will. If it's just formed of controllers that were previously in the patent office and are now in the appellate board, then it's susceptible to groupthink. Whereas having to appeal to high courts means that you bring in an entirely new set of legal minds that kind of apply their thinking to it, which can provide for better decision making. A third reason is that it simply might be that IPAB was ineffective because of the lack of funding or other things that we talked about. And maybe the government will accompany this ordinance with higher funding and resources for high courts to deal with litigation, and that might improve things. A fourth reason is, this is purely an Indian kind of a way of thinking. But from what I know, appellate board positions, at least in some, not necessarily in the IPAB, are often positions that are awarded to people who might be eligible for promotions in the various courts across the country. But when there are vacancies unavailable, or when there are certain reasons to not appoint a person here or there, they may get posted to the appellate boards, which may not be seen as either as something that's seen as a worthy promotion in society. Like you make it from the district judge to a high court judge position, that's a clear kind of signal that you are really appreciated in the community, whereas an appellate board might be seen as a punishment posting possibly. So it's so that kind of, by eliminating the appellate boards, you've taken away the problem entirely, that all judges now kind of go down the same path of promotions and appointments. So that might make sense. And then, I mean, one last, very last reason is administratively it is simpler to have a single chain of courts rather than to have a film certification tribunal that is separate and an IP tribunal that operates in its own space, and then all of them eventually have to come to the High Court anyway. So why not just go to the High Court? So I kind of gave you the laundry list. And,
yeah. So let's go back to what we were discussing. What can we anticipate as the unintended consequences of such a move, right? So, and especially I want you to bring in this angle that, say you are a US company which is looking at investing in India or doing engagements with Indian companies. How would you look at when an appellate body gets dismissed and then the entire decision making goes to a high court system, which we know is already loaded with lots of cases, the delays are high, so on and so forth. I mean, no, we don't need to speak about that in more detail. So how would that act out?
Right. I think so. The first way to think about it is that there is a legitimate role for the high courts to play in the IP laws, or any court for that matter, even the district court where you may file an infringement suit or theft of trade secrets and things of that nature. So I don't think we should minimize or in any way kind of refer to the courts as not having a legitimate role in this process. I think the courts very much have a legitimate role, and the high courts, even though they are generalist courts, tend to have high quality judges and kind of valuable things happen in the high court. A lot of high court judgments and high court cases tend to be of importance, and I think we should definitely ascribe that. What I would say is that as an applicant, let's say a foreign investor that has a portfolio of several applications in India, what you want really is an legal environment that is relatively predictable and has fast resolution time in some sense. So for example, in the patent office, there is a lot of administrative law that happens. The way inventors are named, the way fees are paid, the way patent applications are evaluated for novelty, all the requirements around compulsory licensing and statement of working in India, or restoration of patents that have lapsed for some reason. So there's a lot of administrative law part which is not worthy of in my mind, likely worthy of a high court litigation. It should be a pretty straightforward thing. For example, let's say if you were an applicant, right, and you filed an application and you had a inadvertent error of omission where you did not name an inventor on the application, right? And then at a later point, you want to add an inventor. That's a very simple administrative thing where you say, this was an honest mistake on my part. I should have named all inventors as the law requires. Now, please allow me to add this inventor. Now, the patent office should allow you to do this. Should be pretty straightforward. Or let's say your fee did not go through for some reason. Let's say the check was bounced for some reason by the bank, and now your fee is not received. I mean, most payments are electronic, but I'm taking this as a hypothetical, right? So if the patent office doesn't receive your fees, they may lapse your patent because you didn't pay the maintenance fee. Now, the simple remedy is administratively pay the fee and restore the patent. But in any of these things, if there is arbitrariness or lack of predictability from the patent office, what the applicant wants is a quick and easy mechanism, because this is an administrative issue. You can go to the appellate board and simply say, look, I mean, the honest mistakes the patent office probably takes care of on its own. But there can be, as you can imagine, small variations in how the law is interpreted that are relatively easy for an appellate board to resolve, as opposed to going to the high court for decision related to inventor names. I mean, for example, that just strikes me as crazy to go to a high court to say that any decision related to inventor names should go to a high court. I mean, the appellate body should be able to take care of it. So kind of coming back to your question, I think as an applicant, the simplicity of an administrative process can be corrected through an appellate tribunal is attractive compared to the unpredictability and cost of a high court litigation. And the fact that this can be changed at the stroke of a pen with an ordinance, when there are likely tens or hundreds of appeals pending before these tribunals, just seems like a strange thing, because now Anybody who has an appeal has to now find the right court, whether it's Delhi High Court or Bombay High Court or somewhere, to go and refile these papers and litigate and then kind of sort this out. So I would say as an investment thing, the fact that you are going from a dedicated queue for an IP issue, for the IP issues that I outlined, the IPAB is where all your appeals go initially, right? And that dedicated queue is handled by that appellate body and is disposed of. And if you win there, then you're done. It's easy. You're in a dedicated queue. But now, through this new kind of ordinance, you have to take everything to the High Court. Anything that you want to appeal goes to the High Court or the commercial courts in case of certain aspects of the law. What that means is you are going from a fast lane to a kind of you're going from a dedicated fast lane where you have paid for it or whatever to a kind of a road that has all kinds of people on it and you never know when your turn is going to come. That is not something that is good as a technology investor, for sure.
Mihir, just extending that, one best case argument, for example, which you spoke about, is this being seen as an extra step that needs to be gotten rid of, right? Now, I'm thinking of it from a macro level, given that economies are becoming complex, there are so many issues of technology. I mean, we are still figuring out, right, which IP applies to many of the products that we use. Given that there's so much fluidity in this, we need comparative advantage to develop, right? We need certain institutions to become experts in handling, say, these technology related cases, certain other institutions to do certain other things, right? As they get experience, they'll get better in some of the other things. So now when I see this move, I think it's going against this specialization, right? It is trying to put everything to a high court, which is already quite burdened with low state capacity. So unless we are going to dramatically improve high court capacity, which I will certainly give a thumbs up to, this is going in the opposite direction, right? And on many thorny issues of the new information age, we'll actually be on the wrong end of the debate. Don't you think so?
I would say that depends on the facts of the situation. So as I said earlier, that if there is groupthink within the IP Appellate Board, if there is evidence of that, and I'm not aware of any that kind of makes me think that there is, but if there is evidence of that, then there is clearly merit in bringing in other courts and people of not necessarily specialist IP domain, because they can look at the law and the case and kind of give an opinion that's separate from like a particular mindset that certain bodies tend to develop. But in the absence of that, I would agree with you. If there is no evidence of groupthink there, and if there is no evidence that an applicant essentially, as soon as they fail at IPAB, they take everything to the High Court. So if that's the situation, then the resolution of the board makes sense. As everything is going to the High Court anyway, then yes, there is no benefit. But I wouldn't believe that to be the case. I mean, one is that the controllers of the patent office are subject to their quality and evaluations annual on a regular basis. I'm aware of many applicants who have procured patents in tricky circumstances where interpretations of law were required, or where certain situations where they were able to get help from the controller to figure out how to get past that and get their patent in proper order. So I don't think the adversarial nature exists between the applicant and the controllers necessarily, and it should not exist between the applicant and the appellate board either. What should exist really is transparency in the interpretation of the law and consistency. So to the extent that the appellate board were working in those terms, providing transparent and consistent interpretations, there was no reason to kind of move away from it.
Right. Actually, on the second point, the groupthink part which you mentioned, right, and you addressed it right now, I would think the solution to groupthink would be to strengthen that institution rather than taking it away, right? Because there can be groupthink in high courts as well. You know, we know that courts are and the judges come from a very small network of people. So it might be a groupthink of the other side, right? Like it might. So the solution to both would be to strengthen those institutions rather than take them away. In any case, one point that you had mentioned, that patent attorneys could sort of make their case to the IPAB, right? Can they do that now in the new regime in front of the High Court, or how does that work?
Right. So let me make a small correction. So what I mean is what we are referring to are patent agents. So
Agents.
the way the law works in India is that an engineer or a science graduate, anybody with a science or engineering degree, can take an examination to be a patent agent. Right. And that relates mostly again to the administrative aspects of the patent law. And then they can file applications on behalf of their clients, and they can also go back and forth with the examiner on all the objections and various aspects of the patent application to the point to getting it granted or and so forth. Now, when the controllers reject the application, the patent agent can argue and submit. And if that fails, the patent agent could go to the appellate board and say, remedy this, help me remedy this situation. I believe the controller has got this wrong. So the difference is that the patent agent is not a lawyer. It's not. I mean, a lawyer can also be a patent agent, but a patent agent doesn't necessarily have to be a lawyer. So what that means is that a patent agent could go to the appellate board on behalf of their client and appeal something in their case. However, currently, I mean, that was a benefit of having the appellate board, that a non-lawyer or a patent agent could go and do this. But for high courts, when the cases are automatically heard at the high courts, high court as practice rules prohibit non-lawyers from practicing. So essentially, for every applicant that used a patent agent to appear before the patent office, now has to instead hire an attorney. And that attorney may not necessarily, and in many cases will not have a patent background, will not have the technical background that the patent agent has. So this is just additional cost, and in fact, it's discriminatory against the patent agents because they took the patent agent exam. They spent the time and the money and the effort to qualify themselves with a view that they would be able to practice both in front of the controllers in getting the applications reviewed and examined and allowed, and in front of the appellate board when there is a dispute that arises. Now their entire appellate litigation arm of their business has been taken away. At least the way it looks like. I mean, there might be clarity from the government, but it seems unlikely, highly unlikely to me that the high courts will simply just let patent agents come in and argue their cases. That would go against the grain for high court practice over hundreds of years.
Yeah, right. So are there any other unintended consequences you foresee?
So it's hard to tell, but I think the intended consequence is unlikely. The intended consequence of streamlining litigation, of simplifying and reducing litigation, and of kind of easing the whole process that the IP office has, it's unlikely because now you are getting all these other effects that are just mixed in. The fast lane being taken away into a high court mixed lane of litigation, the fact that patent agents can't practice, the fact that administrative issues are now directly going to a body like a high court, whereas the high court's time could be used for much, much more valuable litigation. So I would say that whether any unintended consequences can happen, yes, it's possible. First, let's talk about the intended consequences likely not happening.
Yeah.
The unintended consequences are likely to be that one is that there might be higher cost at the time of filing and prosecuting patent applications because more applicants would want to kind of not rely on the existence of the IPAB to remedy things quickly, which means potentially fewer filings or higher filing costs at the initial stage, and also uncertainty in getting grant, which means at a higher cost at a later stage. The second is related to kind of, and I would say this is a broader business issue, is that a stable and modern IP legal environment is a key indicator to technology investors and technology venture capitalists or technology entrepreneurs. Because if you think about all the developed economies where companies make a lot of revenue out of R&D, the way that revenue is ensured or is captured into assets is through filing for intellectual property, or even the brand identities as identified through trademarks and so on. And a big part of that is that worldwide there are relatively very effective patent offices, effective appellate bodies, and a streamlined and well-working process that gets you results within a matter of months, even in complex litigation. And having that predictability makes a country attractive. So I can tell you that, for example, German courts are known for resolving patent disputes very quickly in a matter of months, as opposed to American courts where you may go for years before you get a verdict. For example, the Google Oracle litigation has been going on for 11 years between the Northern District of California, then the Federal Circuit and the Supreme Court, and getting tossed back and forth. So that kind of a delay is, I mean, in that case, it's merited. It's a very important case. But having an 11-year delay from initial filing to a resolution of a case is problematic. And Germany has actually managed to attract litigation to its jurisdiction by giving good, high-quality verdicts relatively quickly. We seem to be going in the opposite direction, where we are saying our IP laws were relatively settled. We had this tribunal in existence for a decade, but we have now suddenly changed our mind even without deliberation in the parliament and are just putting everything back in the high court, which just makes it less attractive for any technology company to say that, okay, India is the right place for me to perform R&D and get IP protection. Just a negative signal.
Absolutely. Yeah, that's very well put. All right. So apart from the IPAB, there were a bunch of other tribunals which were sort of disbanded as well, right? So one of the ones that I have been following is the film certification one. So FCAT, which was a Delhi-based body, and that was similarly structured, Mihir, in the sense that the CBFC, which is our censor board in common parlance, so it had a body which reviews all films. It also had the power to just say, it's not a certification body per se, because it could also say that I'm not going to review and not going to give you a certificate at all. So it's doing much more than just certification. But if you weren't happy with their decision, you could go to a review committee within the CBFC. And if you were not happy with that as well, then you could go to the Film Certification Appellate Tribunal, FCAT. And that was the one which some of the recent movies which were deemed to be very controversial were actually passed by FCAT, and that's why they were released as well.
So one question, Pranay, for you there is for the FCAT again. It seems like it's a very similar body in terms of the membership of that body will be people of experience and expertise in this domain. And in fact, in the case of films or other entertainment content, there is a much greater time value for money. So for patents, for example, patents are valid for 20 years now. Obviously, technology industry moves quickly, but even then, when you're applying for a patent, you're looking for a 20-year kind of term where your patent is valid and you can enforce it and you can reap benefits of your R&D through your product. But for a film, I mean, if you want to release the film in a month from now, I mean, assuming that, I mean, in normal circumstances, the release cycle and the timing and all of that matters a lot in the film business, doesn't it? And so
absolutely,
does
yeah.
that mean
problem,
you have to go to the High Court?
No, yeah, exactly. Now it means you will have to go to the High Court, right? Yeah. And there's another bigger angle to it, Mihir, given that now there's so much content on OTT platforms, right? And that OTT content is currently not regulated by the central board or the CBFC. And they have been pushing for more control to even have give certification to whatever happens on OTT. Now imagine the CBFC is already constrained in resources, and if they have to regulate all OTT content, which I think there should be a level playing field like there is with films. So that is not disputed, that there should be some overview, at least for certification, right? Age appropriate certification, if nothing else. For that age appropriate certification, if you have one body which has to do all this, and imagine if you don't agree with their review, you have to go to the High Court, it's going to be quite counterproductive. So the solution to this, one of the ideas that my former colleagues at Takshashila had put, and we'll put the discussion document up with the description, was to have something called independent certifying authorities. These will be independent. They will get license from the CBFC, and CBFC can lay down very specific conditions according to which age appropriate certification can be done, right? And then ICAs have to do this certification on their own, so they can specialize in some domain. Some might just try to regulate, be a more sanskari type of ICA. There might be some other ICAs which will not, which will be have a more liberal approach to age appropriate classification. So there might be a specialization might develop. Some might be good at doing sports certification. Some might be good at doing, say, discovery channel kind of content certification. So that and of course languages as well, right? So that chance is there with ICAs, and let the CBFC regulate this ICAs, license them, remove their licenses if they are not conferring to the conditions which are laid down. So this will sort of aid increase capacity to manage the OTT content regulation that CBFC is pushing. But now with FC80 abolition, I think we are going to go in the opposite direction, and I am sort of quite sure that CBFC will get through regulation on OTT in near future, because that's becoming a big political issue now. So, and which means that we are going to have more delays, and that's not a positive thing according.
Well, we might see one day soon where a top executive from a chip development company in Bangalore meets a top executive from a film corporation in Bombay High Court, and both of them are sitting waiting in the courtroom for the luminaries to deliver verdicts on administrative appropriateness of their patent applications or their films. And I think it's not a good idea for any business to have its executives or content creators. These are creative parts of the economy, technology as well as entertainment. And for content creators and creation investors to be stuck in court or to be even hauled to a high court rather than a simpler body like an appellate tribunal could be it's not a pretty sight in my mind, just that imagination.
But Mihir, I am thinking of another angle. Maybe a good movie on semiconductor manufacturing will come out of it then. Because of that discussion.
That would be a good unintended consequence, if any.
Yeah. So on that happy note, we will end this episode. Thanks a lot, Mihir. We learned a lot about intellectual property and IPAB and what it does. Thank you.
Thanks, Pranay. Great talking to you.
The Takshashila Institution is an independent, non-partisan think tank and a school of public policy. We have education programs lasting 1 semester and 1 year that are tailored specifically for people like you. They are all online and you can take them from anywhere. Admissions are now open for our 12-week graduate certificate program in public policy, defense and foreign affairs, technology policy, and health and life sciences. Visit takshashila.org.in/courses to find out more. If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.
I hope you enjoyed that show. If you aren't following us on social media, please do. We're IVM Podcasts on Twitter, Facebook, and Instagram. We'd like to thank our sponsors this week, thewholetruthfoods.com, PayPal, Cred, and SIAT. Thank you so much for working with us. We really appreciate it. First up this week, let me tell you about Cyrus Says. We featured popular YouTuber and actor Prajakta Kohli, who took us through her journey of content creation. We also had conversations with Vasanti Hariprakash and Sachin Kalbag this week. Really great conversations. Do check those out. Vineet Kanabar goes solo this time on Storytellers and Storysellers as he talks about his favorite IPL ads and how brands have been making content around the Cricket League. On The Habit Coach, Ashton was joined by Arjun and Somesh of the Fighting Goat podcast to talk about fitness for combat sports like the mixed martial arts. On Nankari, Sadaf and Archit discussed the diet and lifestyle of athletes with the host of the Millennial Athlete, Shok Ramchandra, who is also a pro badminton player and coach. Ambarana opens the 4th season of Know Your Kanun with a list of things he has planned on the show for us, including episodes on immigration law and on career prospects for law students. The IPL season's on and we've definitely got you covered. Tune into the Edges and Sledges podcast if you're looking for English, and if you're looking to listen to something in Hindi, definitely check out Khel Neeti. Both are great shows with great takes. And with that, I hope to see you again next week.
पेश खिदमत है आपकी शान में हमारे अंजुमन से. Hi, I am Sadaf.
And I'm Archit. खाने का इतिहास, economics, policy, psychology, सब है मेन्यू पे.
Only on the Nankari podcast every Wednesday, सिर्फ IVM podcast app या वेबसाइट पर, या फिर जहां से भी आप अपने पॉडकास्ट सुनते हो.